agreement with the amendment. And I think, Cameron, certainly feel free to raise your hand here if you have other thoughts, but I think we can certainly begin to pull this information and report together for November 15th for the statutory deadline. The things that occurred to me just in my first blush were, there are many times, and this is where I think it would be challenging. So for instance, the section in there about identifying fraudulent claims that are appealed, whether they're overturned on appeal. Sometimes we don't know it's a fraudulent claim or a misrepresentation of fact until it goes through appeal. And even then it could go to the Supreme Court. So from that perspective, we may not always know, essentially it could be just a conflict of understanding between the claimant and the employer as to what happened, and only on appeal does a determination be made. It doesn't necessarily mean that it's fraudulent. So I think from those perspectives, we're really trying to focus on those where we either have know that it's a fraudulent claim or have a high suspicion that it's a fraudulent claim as it is going through the process. I think the other piece in here that caught my attention was simply just because I know there's a distinguishing of the two at the federal level. There's a difference between claimant fraud versus identity theft. And I didn't know whether or not you felt the need to consider the two differently. Because claimant fraud is, the person is who they say they are. They're just misrepresenting facts within their claim to receive benefits versus, some type of organized crime, identity theft situation, which we saw during the pandemic. And unfortunately that leads to improper payments as well, but there's not necessarily a person on the other end, that specific claim doesn't necessarily represent a person. It is probably an organized crime situation where multiple claims are being filed with the sole purpose of defrauding the system. And I think we can certainly, we would hope to be able to treat those two differently because, one speaks to the intent of the proposed legislation versus, something that may be more universal and much larger criminal enterprise than the actual misrepresentation of facts, if you will. So those were the two areas that caught my attention. Cameron, just so you know, the link, I think Damien sent out the revised amendment or newest amendment, but it's also in the chat too if you want to pull it up.
Thank you, Commissioner. I think your concerns are noted, and I think they're legitimate. I guess the question for Senator Brock at this point is whether he wants to tinker with the language further or let the House clean that up if the bill goes to the governor. And certainly, I think if the report came back with those statements saying we weren't able to do this for the following reasons, I think we would understand. So I don't know how you want to proceed, Senator Brock, if you want to make some quick changes.
Well, there may be, and I'll defer to Damien in terms of just potential language change, that when we refer to claimant fraud, refer to it fraud by the claimant or any other party.
And I just say that Cameron, in case you can't see him, Michael, Cameron has his hand up too.
Yep. We'll let Damien answer that question first, whether those are easy fixes.
Sure. So we do define unemployment insurance fraud in the draft itself. So right now it says it means a claimant's intentional misrepresentation or knowing non-disclosure of material fact. But we could say means the intentional misrepresentation or knowing non-disclosure of a material fact by a claimant or any other party if that makes more sense to the department, and then in their report, they could break out, you know, the differences between claimant fraud and sort of an organized criminal effort, which obviously has been a nationwide challenge during the pandemic. So does that make sense from the department's perspective? Would that work?
Sorry, I was on mute. I don't think it really, I think it works fine for us. I don't think it causes great consternation even the way it is right now. I just wanted to make sure we were saying the same things and meaning the same things, that there are two populations here. And we can certainly put that in our report. And if you want to change the language, that's fine too. But I think we're all in the same understanding. And again, I don't know if Cameron has something he wants to add.
Cameron, you had your hand up.
I don't have anything to add on that piece. You know, I think, you know, Commissioner, I think we'll be able to kind of distinguish those things. I think even with the language that we have, so I don't know that we need to change the law to address that. I think in a report, I think it would be absolutely appropriate, as the Commissioner mentioned, to kind of distinguish those two things, because one of them can be much more prevalent than the other. And so the one just concern I had, I wanted to raise, and it really just kind of hit me as I was looking through the most recent language. I want to be very careful how I present this, but I think it's an important thing to take into consideration. I want to make sure we're being transparent with the public as it relates to what the legislature is asking us to do here. But I also am or would be concerned about the depth that we would be able to go into in a report that would then become public, explaining to people what we're doing to combat fraud on the identity theft piece, as the Commissioner mentioned, because we're very aware that the same organizations that are trying to access our systems in order to steal from us would then be aware of what we're doing. So I want to just put that on the table. I don't want that to detract from the work that needs to go into this. I don't know if there's a way for us to have the report be confidential, if that's something that the committee can do or would be interested in. Again, I'm sensitive to the transparency piece there, but I do want to acknowledge that if it were to just be an open public report, I think it would caution me as far as what we would totally divulge in that report. Again, especially as it relates to trying to combat the identity theft that the Commissioner mentioned, dealing with your normal run-of-the-mill claimants, not reporting wages to us, stuff like that. I'm more comfortable sharing. I mean, that's pretty open, and I think we can do a lot more to be a little transparent there. It's the identity theft that I'd be worried about. So sorry, that just came to me this morning, and I wanted to bring it up.
I think that's appropriate, Cameron.
I think that's a very valid concern, and to the extent that we could protect, say, sources and methods used to protect against certain kinds of fraud. In other words, the protection of security measures, and that's pretty standard in our Open Records Act as well, is it not?
I think so. I probably referred to Damien, Commissioner. I know you were about to jump in there, Damien. I don't know if you have any thoughts you can have. I mean, it's something I guess we could flesh out as we move forward. But I want to make sure, Senator Brock, we're able to provide you with what you're looking for and have that frank conversation about what we're doing, because I think it's important. I think you're highlighting concerns that are important, but just recognizing some of that information we may not want to become public facing.
Could we put a notwithstanding clause somewhere in there? Or,
I think what we can do is just add language in subsection C that says, to the extent necessary, or basically saying the department may omit sensitive information regarding the specific strategies used to detect fraudulent behavior to the extent necessary to, enable the department to effectively detect and prevent fraudulent, activity within the system.
Why don't you come back to us? We're going to, with that language, and we'll move on right now. And we'll vote this out probably at 11. What time is it now? 10:19.
It's 10:19.
Senator Brock, do you also want to address the commissioner's concern on the difficulty in appeal reversals because he doesn't know the nature of whether it's a fraudulent claim?
No, I think that's understandable. And I guess in effect, to the extent practicable, maybe the kind of language that would cover that. I gather though from what the commissioner says, he doesn't view this as a major problem that would affect reporting in any material way.
Okay.
Yeah, and it's just for us, it's a new, we'll have to devise what our method is for tracking, collecting, and reporting to meet the needs of the report. And it just occurred to me that, as we're trying to figure out whether a claim is marked as fraud, sometimes you don't actually get to that knowledge point until following an appeal or multiple appeals of some kind. So, yeah.
Okay, so we can, I guess I'm just looking for a decision here from you, Senator Brock. Do you want to have Damien try and fix that as well, or let it go to the House?
I would let it go. I don't think that requires much of a fix unless just simply words to the extent practicable. And Damien, do you have any thought on that?
Yeah, I think, that's an easy add right now. And so it would basically say, to the extent practicable, identify the number of fraud determinations that are appealed and the percentage of those determinations that are reversed following the appeal. That's basically what we're looking at, right? Or am I misunderstanding the conversation?
No, I think that's it.
Yeah, and I don't see any difficulty with that. And then that does leave the department, the ability to just say there are additional, fraud determinations that are pending appeal right now, because that's a natural part of the process. Appeals take time. And sometimes the issue on appeal, is a very complicated one that could be stuck in that process for a while. Sometimes it's simple and could be adjudicated more quickly. So yeah, I'll add that language.
How much time do you think you need on the other?
Just a few minutes, and then I'd like to just send it to the editors quickly. So if you give me, say, 15 or 20 minutes.
Okay.
Does that work?
With respect to the issue of the security of methods and so on, do you feel that you're able to deal with that, Damien? There is a provision in the Open Records Act. It's 1 VSA 317C25 that excludes certain kinds of things such as security procedures and similar information if disclosure would threaten safety or security. That would seem to fall within the exception that's already there in the Open Records Act.
That's exactly the language I'm going to use, but since this isn't a Public Records Act request, I think it's just makes sense to include it in here, but I'm going to use that language regarding disclosure of techniques and procedures for investigations.
Okay, why don't you come back at 11:15?
Oh, perfect. Thank you.
Yep.
That's great.
Okay.
I'll see you then.
So committee, thank you, Commissioner. I think we're all set. Thank you,
Thank you,
Cam.
everyone.
Thank you. So we were talking about the gap funding, and in 6 minutes, we should have David Hall and Joan Goldstein with us. But I think I've framed the major remaining issue, at least in my mind. There was I do want to flag the issue of BIPOC and gender preference. Um, I'm only laughing because of the testimony I heard yesterday on it. I'll fill you in on a sidebar on that. But anyhow, if you recall, we were concerned with the constitutionality of what had been done previously when we set aside $5 million for those two groups. And David Hall wrote up some language that, to the fullest extent possible, avoided any kind of constitutional favoritism. And it said, help all kinds of groups who have experienced age groups, disability groups, or just who have had past treatments that have been less than ideal, so to speak. So the House, when they saw that language, I explained it to them, they really sort of rolled up their sleeves and say, well, how are you going to implement that? So
yeah, good question.
I said, well, we didn't really take testimony on the difficulty in implementing that, but we were trying to, we put aside $1 million, you recall, to give preference to those kinds of groups without naming the groups per se. Anyhow, they came back, and you'll see in their amendment, they took out the $1 million, and they took out, and they just went back to BIPOC and gender, and so said those people should be paid attention to in terms of outreach for these grants. So that's one thing you'll see. I don't know if you're okay with that. I'm not sure that I would fall on my sword one way or another on it, but you'll see that language. I'm trying to use this brief time we have now before we actually see the language, trying to remember what else was in there.
So it was outreach to those particular groups as opposed to outreach more generally on groups that have been.
Right. Yeah, they went back to just naming those two groups.
I don't like that at all, quite frankly. I mean, it's just, to me, it's the same problem. It's just doesn't have a number attached to it.
Well, it doesn't. Well, I don't think it's quite the same problem. There's no preferential treatment on the grant. It's just making sure people in those communities know about the grant.
Right.
So
yeah, it's an outreach education piece, which is critical.
Oh yeah, but it's an outreach to specific groups as opposed to those who may not historically have gotten the information, such as some rural Vermonters, for example.
Well,
people who have been third generation welfare recipients.
Well, maybe, I mean, maybe when we hear from Joan, I don't know. I didn't hear Joan's testimony, so I don't know whether she said she would have problems implementing the Senate version, but maybe she would have less problems if we used the Senate version, but just applied it to outreach as opposed to grant distribution and setting aside the money. So maybe that would be our compromise. I don't know if the rest of the committee would be okay with that. We don't want to, put this in perspective. This bill, the appropriations chairs have control over it. There's no conference committee now. I give them credit for deferring to the policy committees to try and work this out. But if we don't work this out, they're going to work it out. They're just going to make a decision. So,
right.
So what else was in there? There was the issue of, you recall how much, even for the first group that we came up with, how much was the grant going to be? The way the House wrote it, it said that the grant shall not exceed the lesser of 3 months worth of fixed cost or 150,000. Joan came in and said, we thought that meant that you either it left out not to exceed. It just says you get either the lesser of 3 months fixed cost or 150,000. And we heard from the House that they meant it to be that there was also a third choice, which is if the lesser, it could be less than either 3 months or 150,000. That's what the language clearly said. It shall not exceed the lesser of, but they could give a third alternative. So we put it shall not exceed, or it shall be the lesser of the tax loss in 2020, 3 months or 150,000. They came back and didn't accept our language on that and said they didn't even change it. They just kept it that way, which I think is a non sequitur because it doesn't make any sense, because they say it shall not exceed the lesser of these twos, but they don't say how they're going to calculate if they want to give less than those two. So,
Right.
Let's see who joined us there.
No one has joined us.
Okay.
Becca's on the phone, and Keisha, I don't know where Keisha's coming back. Oh, there's
Hi,
Joan.
Joan. Hi. Good morning, Joan.
Joan.
We're just talking about your issue, sort of waiting on David Hall to put something up on the screen for us. But in the category of killing time, we were just talking about the issue of, and let me see if I got this right, on the amount of the grant in the first group. You had told us that you meant it to say they either get 3 months or 150,000, but that's not the way the House wrote it. They said it shall not exceed the lesser of those two. So they could give a third amount that's less than that, but no direction to you as to if you had a third choice, how you would get to that number. Am I clear on that?
Yeah, I mean, I think it's getting confused because I just saw some other language that I think is back to the way House had it, which is an amount not to exceed 3 months of fixed expenses or $150,000.
But let's just to be clear, your preference would be one or the other of those two, not a third amount, right?
Right. Well, it keeps it simple, right? Because I don't know what the third amount.
Right. I agree with you. I don't know that I agree that that's where we want to wind up, but I agree it's simpler, and I agree the House coming back with the same language leaves an open question. Is you have the right to give less than 3 months or 150,000, but you don't know what amount to give. And there's no guidance as to what amount to give if it's lesser than that. So we need to get one way or the other. Anyhow, I don't mean to cut you off, but David's with us. It's a better starting point. David, good morning. I think you have two documents that you could help us with. First, if you could show us the changes that the Senate made to the House, and we could walk through those. And then you could walk through the proposal that the House is now making back to the Senate.
Sure. Let me find the first of those two. Man. Okay. So good morning. David Hall here, Legislative Counsel. The first document I'll pull up will be, this is what the Senate did relative to the House passed version. So the House version is underlying, the Senate changes are in yellow here, right?
Right.
So the Senate changed the source of the funds from general fund to ARPA funds, and then added in this A1B, this reservation of $1 million, direct an agency to work with community partners, Vermonters who are members businesses owned by Vermonters who are members of underrepresented communities historically experienced unequal access to state economic benefits and services or suffer discrimination due to race, gender, socioeconomic status, citizenship status, disability status, or other similar factors.
Okay.
That is new from the Senate. And then the standard eligibility criteria that you have to be a domiciliary and that you can be organized, however, continues. And then Senate added in 3 a little bit of additional language on whether you're opened or closed but going to reopen. Senate said you have to submit a written plan to demonstrate that you will use the grant funds for business-related operations and economic recovery, and that you're either open or you're closed due to COVID, and you will reopen within 60 days of receiving the grant and use those grant funds for reopening. So 4 here, the business suffered an economic loss due to the COVID-19 public health emergency and has filed a 2020 tax return that demonstrates a tax loss. I know there's been a lot of discussion about, what the trigger is for whether you are eligible. Everybody agrees with the premise that you suffered some sort of loss or harm. From there, though, there's a lot of nuance, and I'll take 20 seconds here to remind you all of the trajectory. The reason that this concept of economic loss and that verbiage itself is used in the CARES Act bills is because that was the standard from the CARES Act itself, that you suffered economic harm or loss due to COVID. And remember that those CARES Act bills all based the loss on revenue reduction in a period versus the prior year period. Started at 75% loss, it dropped to 50%, it then went to just plain loss with a cap at 300,000. So this has morphed over time, along with in a reflection of the kinds of businesses that you're trying to target, right? So when you started with S350 and you were a 75% loss year over year in revenue, you were trying to hit the hardest hit businesses, the meals and rooms, tax filers, and the other businesses that had suffered 75% or more of a revenue loss. Once that happened, the next iteration said, all right, now we can target the businesses that were at 50%. After that, you said, all right, now everybody else with whatever money we have left over, up to $300,000. Remember that the purpose of this bill was originally a gap funding program until and if other federal funding came along. That's why it started as GF. That's why it was limited to 10 million. That's why it was targeted primarily, almost exclusively, to businesses who hadn't received any help. And that's sort of that's consistent with what the Senate passed here, which said you have to show us a tax loss, a net operating loss. Your income has to be less than your expenses. You have to have lost money in 2020 to be able to avail yourself of this $10 million. I highlight that here because the way, in anticipation of the House proposed changes, it has sort of moved a step past that gap concept and really is looking at a massive, potentially massive amount of future ARPA funds and a broader swath of businesses who might be assisted. And so there's, I think, part of the debate, part of the question on where do we draw that line about losses and whether you've received assistance is, who are we targeting now? Are we still targeting only businesses that haven't received any assistance? Or are we now looking ahead a little bit? I frame it for you in that way, we can move on.
Thank you for that.
Yep. So in 5 here, the House had said originally in 5, you only qualify, again, if you haven't received any of the new federal funding as of the December Consolidated Appropriations Act, right? Either you had to have applied and been denied, or you had to have an accountant or somebody tell you you're not even eligible, don't apply. Then you could come to the state and try to get some of this gap funding. The Senate said this additional language on lines 18 and 19, it added in state assistance as well. You guys really wanted to button it down and say, this is for people who have received nothing, state or federal. You know, maybe you got the original PPP1 or the early EIDL, those people are okay. But since those programs were expanded and refunded in December, that's, you know, you can't have received any of that federal money. Obviously, since both the House and the Senate version, you know, the ARPA funds have come along. There is new federal funding. So I don't know that the new House proposal gets rid of that this five altogether. We can look at it, but
David,
yes,
can I ask you a question on the ARPA funding?
please.
Is that, I assume we're going to be asked to design a program to put ARPA funding into businesses to help sustain them. Is there a segregated pot of money of ARPA for that, or is the state going to have to take its flexible funds and put it there? I know there's some like broadband money and other housing money, but is there a pot of money specifically for businesses or small businesses within ARPA?
I don't know the answer to that. I'm sorry.
Okay.
Well, I think this is important because I think we're getting ahead of ourselves with ARPA money. I mean, this committee still isn't clear on the guidance. I mean, maybe Joan is, but I mean, I'm on one hand, we're being told we're not getting guidance for 2 months. And on the other hand, we're writing bills that are expecting ARPA funding. So it's a little troublesome to me because we aren't yet clear on what we have the responsibility to appropriate and where we're able to appropriate it and for how much.
Not to get sidetracked on that issue, but I correct me if I'm wrong, David. When we made our proposal, we had this funded like the House did out of general fund because ARPA still hadn't become clear and it was going to take a month or two more for us to develop a spending plan for ARPA funds for small businesses. So we needed to get this money out the door. When I made my presentation to appropriations, our proposal was out of general fund, just like the House. And the Appropriations Committee and Joint Fiscal Office figured out a way, I think in the first two sections of 315, to allow stuff in this bill that's being funded with ARPA to be front loaded with general fund as excess receipts of some sort to be paid back with ARPA money. So it's a little confusing to me that what the Senate passed is with ARPA funds. I think there's some qualification on that. I don't know if David could shed any light on that.
Yeah, that's all accurate. And that shift did happen in Senate appropriations. It is incidentally, it's also happening in House appropriations. You know, when Commerce passed its H-159 bill out of Commerce, that was all general fund. And then it came out of House appropriations and they had converted the majority of it to ARPA funds. So it is happening. This bill, H-315, in the first section authorizes the Commissioner of Finance and Management to start spending money in anticipation of ARPA funds coming in. And the Joint Fiscal Office has been advising both House and Senate Appropriation Committees on the use of ARPA funds. And I believe my understanding so far is that as long as you can link the expenditure to harm suffered due to COVID, you know, for business recovery expenditures, it's similarly flexible to the CARES Act. That said, as Senator Clarkson observed, there is not final guidance yet at this point, so we don't have the 50 FAQs that we had under the CARES Act. But to your point, Senator Sorokin, that shift, yes, is happening, and it's happening in multiple bills on both House and Senate sides.
Thank you.
So page 3, mostly the same. You guys in subsection C here, as I characterized to the House, this is a third category within, the provision governing the amount of the grant. And it would be the lesser of the actual loss that's demonstrated on the tax return, or the 3 months fixed expenses, or 150,000, whichever is less. So it definitely cuts both ways. If you only show $1,000 loss on your tax return, under the Senate version, you would only get $1,000 because you only had $1,000 loss, versus, on the House side, you show any amount of loss, you could get, it shall not exceed the fixed expense of the 150. It theoretically could be less under the guidelines that the agency adopts. This is just a maximum amount, right? And so that's a pretty fundamental policy difference between Senate and House. Should the maximum amount include the tax loss shown in 2020? You guys, the Senate had essentially jettisoned the 30-day initial period, and then the subsequent priority factors for grants. Remember, the House had said, for this first 30 days, we'll take applications, but we'll only award grants to businesses who have received no assistance whatsoever. After that, the agency can consider these priority factors and determine the priority for subsequent grantees. Senate took that out altogether. I think largely because, again, your thrust was, we are only trying to help businesses who haven't received assistance here. The Senate added in this piece on page 5.
So can I ask a question on that? Maybe I'm jumping ahead, but if there was a second tier in the House language, is there any restrictions on who could get that leftover money and how much their individual grants would be? I know there's some loose criterias here, but I don't see anything that is concrete as to the number that somebody would receive as a grant.
Well, that's still governed by subsection C. So we start off above with eligibility, right? That tells us what the universe of eligible businesses are. And, again, that you have to show the tax loss or the operating loss. You have to, at least as so far constructed, you have to have applied for or not received or not be eligible for the consolidated federal monies. So you have to meet all of those qualifications first off to even be eligible. Once we get to that universe of eligible businesses, under the House version, they say for those first 30 days, you get priority if you've received nothing. And then after that, continue giving priority to businesses who have received nothing. And if there are businesses that received a little bit, for instance, under the PPP-1, or who received state assistance, then they would get some sort of priority. It's going to be up to the agency to determine what.
Are they
but
governed?
Everybody has to continue, has to even get into the tent. Everybody has to meet those eligibility criteria. And subsection C, the maximum amount of a grant, is still in effect for any business in this program.
Okay, so the second tier would also be subject to the lesser, not to exceed the lesser of 3 months or 150,000.
Yes.
Okay.
Yes.
Okay. So the other difference that you really, you may have focused on or not, but you said, it sounded like you're saying we had similar criteria for the qualifications on economic loss. My recollection is they just use the word economic loss without any definition. And we said there had to be a tax loss. I remember when we talked about it, we were saying, is economic loss $1 and then they could qualify for $150,000? Is economic loss a lesser degree of profits? Instead of making 100% profit, you made 80% profit. Is that an economic loss? So we made the decision that we're talking about businesses that have lost money in terms of their tax form showing a tax loss. And we'll get to what they're suggesting now. I think they've met us a little bit on that, but they changed the terminology. So
Yes, that is correct. The House passed version does say economic loss. And again, that's just sort of a vestige that's grounded in the original CARES Act language. But remember that, as I said before, you used to have this revenue loss comparison period over period. This bill was in part designed to help businesses that could not show a periodic decline in revenue, whether because it was, formed after a prior period or just didn't have an operating history to be able to qualify. And so it was intentional not to include a comparative revenue loss because of the population of businesses that they wanted to help. But yes, as you said, the consequence of using that terminology, economic loss, is it does give more discretion to the agency to really nail down what we mean by that. And I think, Joan's testimony has been pretty consistent that they would look at a tax return and that they would do the unmet need analysis and have to demonstrate loss. But as you said, it does leave the possibility and the flexibility of where, the agency lands on that. Is it mean net negative, for the year, or does it mean you made a little less money, or does it mean $1? That would be fleshed out in the guidelines under the House version.
And I just want to go back and refresh the committee's memory on what we asked of appropriation, and that was we sort of stayed true to what was told to us in the winter when the governor was pushing for this, and in the early months of the session when the governor was pushing for this in the Budget Adjustment Act, that he wanted to help these newly formed businesses. So that's who we're helping. But we did not cut the $10 million. We said, even though I think some of us felt that where that number came from was a little less than definitive, but we did say if there is any money left over, we direct it back to the ACCD to use for economic recovery grants within the new pot of money. So I think the difference really is, let's assume out of the $10 million, the agency, Joan has testified several times that she thinks it's all going to be spent on these new monies. So our bill would be perfectly fine. And but let's say there was $2 million left. We're saying that $2 million gets carried forward to the bigger program coming forward. And, by the time this bill gets signed, and by the time the 30 days kicks in for the first year, which we cover, there may be a month or two difference as to when that $2 million gets spent. But I think what we're trying to do is to make sure we target it better and meet the need that was expressed to us originally, and not have this be a supplemental fund for businesses that have already gotten help under criteria we set up at least twice before, if not 3 times before. And as I said, when I spoke to the House Commerce Committee yesterday, I was definitely open to their idea to say, well, what if there's a business out there that just got a small amount of funds from PPP or economic recovery grants? I said, that's fine. Let's figure out a way to define de minimis. But as you'll see in their proposal, I don't think they've changed their position on that. So let's keep going.
So you see, you just referenced the piece in D, and then the guidelines, the Senate had added this highlighted language, a timeline for accepting applications and awarding grants. And then under E3, the use, again, of grant funds has to be for the purpose of business-related economic recovery. The Senate added in the auditing and compliance and recapture language, which I don't know that we need to read through again. I think the House is fine with that. And then there's this piece that the Senate added about future business grant awards in consultation with legislative policy committees, which was new on the Senate side. And that is that's the Senate proposal. Are you ready to turn
Yes.
to the next piece?
Please, thank you, David.
Sure. All right. So now.
I like your haircut, by the way, David.
Oh, thank you very much. I just couldn't take it anymore. Too many hours in the shower. Okay. So what I hope you're seeing now on the screen is sort of a counter proposal. I don't know what you want to call it. It is the House language, but then the highlights are changes to the House language. The blue rooted in the Senate version, and the yellow is actually just, it's new. The yellow is new from the House. So Section 3, a title change because the source of the funds has changed. It's no longer an FY21 one-time general fund appropriation. It's ARPA funding now, and that's reflected lines 4 and 5 is provided from the Senate. 6 is just, a little technical grants to eligible businesses. There's still 5% for cost of administration, including technical assistance and guidance. So subdivision 3 here, rather than your $1 million reservation for ACCD work with partners, reserve $1 million, businesses owned by underserved populations, et cetera, it's replaced with the directive: the agency shall make best reasonable efforts to conduct outreach, provide information, and provide necessary assistance for women and BIPOC-owned businesses to access grant funds. So conceptually rooted in the Senate, but obviously a different policy approach. Eligibility criteria.
Can you say, and maybe Joan will comment on this, what I just caught a bits and pieces when I was up there that they thought maybe the other version was sort of didn't specify groups as much, was more difficult to implement. Can you comment on what the discussion was like on why they went back to women and BIPOC?
I think, if I recall correctly, it was very, very, very broad. It covered everything from socioeconomic status to people who had been discriminated against, from economic benefits of the state, very broad. I just don't know how we would be able to ascertain that, and whether or not we'd be asking that type of question. I don't know. There was a lot of consternation about it. It was very, very broad.
Okay. Thank you. Let's move on. We'll get back to this, I'm sure.
So just question, David, did you email this to us, this language?
I don't know. I don't know that you all have it. I can.
Most of us were so blind. It's just hard to read up on this.
Yeah. There, I've just emailed it to you.
You are divine.
Okay, so the next piece is the eligibility piece. Again, what I keep calling sort of the universe of businesses that could avail themselves of this money on page 2 here. So a slight change, there would be, rather than the Senate language that said, shall submit a written plan or document outlining reopening, et cetera, within 60 days, this would just require an attestation that the business will use grant funds for business-related operations and economic recovery, and that it's either open or closed, but will reopen. So again, your concept of limiting the use to business-related operations and economic recovery, but just an attestation from the business for that purpose. Subdivision 4 here, this is what we talked about earlier. I'm not an accountant. I can't articulate for you, whether there's a really good reason to use the term tax loss versus net operating loss. And it's, again, shown on a tax return. Let me just say that there's a lot of consternation about how deep a dive the agency is going to do, or how you want them to do, on people's tax returns, whether they need to, take a close look at, for instance, depreciation, whether people have accelerated depreciation to this tax year in order to claim the benefit and show a net loss. I think at the end of the day, what everybody wants to achieve is that the business lost money. That's why we want to help. And these granular questions about depreciation and EBITDA and all this other accounting junk that I don't think I can get into with any intelligence, and I don't know if you want to get into within the
I
statute.
I think the concept is clear, whether it's operating loss or tax loss. I mean, I think you just phrased it the way it is, and I don't think we should, given where we are right now, I don't think we should spend a lot of time on this. The idea is that, there was always a problem in my mind for the past grants, that it was just that the metric was a loss of receipts, and the size of the grant was determined by the loss of receipts, without any looking at the reduction in costs that the business might also have. So this more gets at the profit and loss thing. So whether it says tax loss or operating loss, if the House is agreeable to that, that's, in my mind, progress. So.
All right.
Agreed.
Good. So what I want you to notice here, because this is a big change in the universe, is that they have completely eliminated the requirement that you have not received prior assistance as it was framed in the original House version. Remember, 5A and B said you can only qualify, you are only eligible if either you applied for federal assistance as those programs existed in December in the Consolidated Appropriations Act, or your accountant, your lawyer, your bank, whoever told you don't bother applying because you're not eligible. So to even be considered eligible for this money, you had to check one of those boxes. And they have removed that to broaden the universe, so that the consequence being you could have received some assistance and get to the next stage. You still have to, show a tax loss, and we'll get to the priority stuff about first priority goes to businesses that receive nothing. But but again, as I said at the top, because I think in where we are now, having moved a couple of months beyond where this bill started, where it was strictly focused as a GF $10 million gap program, to now contemplating ARPA funds in a broader swath of businesses, they have sort of streamlined the eligibility criteria here. The amount of the grant you'll see in C, it really just goes back to the House position. I mean, it's the lesser of, and this again is a cap, this is a maximum of the lesser of 3 months fixed expenses or 150. And
So just, I'm sort of a little floored by what you just said. I didn't realize that. There's still two priorities. The first priority is people who have got nothing or not?
yes, absolutely.
Okay,
So among all these businesses that can come in and show a tax loss, first priority will always go to those businesses who have received no assistance.
okay,
And after that, if if there are other people, then the agency has to decide the relative weight of other factors. But first priority must always go to businesses that have received no assistance.
so in their first proposal, in the second tier, or this, after the first 30 days of priority to the first tier, the second tier, they still required people to have applied for PPP first and been denied, or an accountant says there's no reason to apply for PPP because you don't meet their eligibility. They got rid of those requirements now in the second tier?
They got rid of, in this version, they got rid of those requirements for everybody.
But they still in the first tier maintain the requirement to have received no assistance whatsoever.
That gives you first priority.
Okay,
That gives you first priority. So first among equals, 2 people standing in line, agency has to give money to the business that hasn't
Okay.
received anything.
okay. Let's go. Let's start.
So
Yep.
I don't want to confuse anybody. Let me just remind you that the House version of this H315 as it came out, it's the it's the federal programs as of December. So you could have received a PP1 or Idle 1 amount of assistance, but those monies ran out. And when they were recapitalized in December under the Consolidated Appropriations Act, the requirements changed. So that's really the point of reference for whether you've received assistance under everybody's bill. We're not looking before that. We were just looking at as that existed in December.
Okay,
They reinstate the grant administration priority. So it's this 30-day initial period for accepting applications. During the initial 30 days, they can only award grants to businesses that have not received any direct financial assistance from state or federal sources.
okay,
And then after that window, again, continue accepting applications and awarding grants, continue giving first priority to businesses that have not received direct financial assistance. To the extent that there is, money remaining that we've helped everybody who asked for it, then the agency may exercise its discretion to give subsequent priority to businesses based on whether and the extent to which 1, 2, 3, 4, 5. These are the things that the agency would consider and exercise its discretion and come up with some sort of priority system for who would get any remaining funds, if there are any. Again, if they come up with this second tier priority scheme and somebody walks in the door and says, wait, I haven't received any assistance, then agency still has to give that business first priority. That's an ongoing requirement. They have left your subsection E as written and suggested that House Appropriations will look at it and try to make sure, they reconcile how we're going to treat all this ARPA money, when it's allocated, when it reverts, where it reverts to, who gets to reallocate it, so that they have sort of just left this here and put it off for appropriations to look at, is my understanding. In F guidelines, they kept these two changes, but remember that yours said, and for awarding grants, they took that out. The thought being it was too prescriptive, I guess, to set a timeline for awarding grants. It could be covered in the guidelines as is, I guess. I don't know. The 3 is the same as the Senate version. They kept your auditing compliance language. They kept your recapture language. They got rid of your 3A. And as we speak, I believe they're considering some language in another part of the bill that, ties the Embrace funding to ARPA. So that's not actually part of this, but
Okay.
unless you want it to be, but that's something they're looking at because
I'm surprised they got rid of 3A. That was just to keep the legislature updated on the development of a new program with tens or hundreds of millions of dollars. So we get more notice that it's coming to us rather than less notice. Did you hear any rationale for that?
no, they only discussed this in committee this morning
Okay.
from 9 to 9:30, and then I had to leave to go to House General, and I left House General to come here. So I haven't heard anything more from that committee than what I heard in the first 30 minutes this morning.
Okay. So can you go back? I mean, in my simple mind, and I'll be totally transparent here, we had talked about it yesterday in House Commerce. They said they felt they didn't want to get rid of the second priority because there could be businesses got very small grants from the feds and can use more money. And I said I would be open to, and they raised the issue. How would you feel about a de minimis level of grants and letting those people in? And I said that sounded reasonable. If you could pull back up on the screen the criteria for the second round of priority here, I just think it's a nightmare for ACCD to look at these subjective things and decide who's eligible. And I think it'll be just simpler to be done with this. Just come up with a de minimis, say the first group says you can't have gotten anything, and the second group is you got a little, and be done with this. I think we'd have to figure out the amount of the grant. Maybe it's what Joan's suggesting, get rid of that lesser of, or the to the does not exceed, that language. And then we would be done with this. I just really think this language is probably you got to look into whether it's the primary source of income, to what extent. It just all of these things are like so malleable and so fungible.
Let me observe to you that that subdivision B here, the way that it is written is maybe in actuality looser than what everybody perhaps thought. So B intentionally says that it may exercise its discretion to give subsequent priority considering these things. That means that they don't have to. It means that they always have to give first priority to businesses who have not received assistance. But after that, the agency actually has a pretty significant amount of discretion, both to determine who gets, who else would get money and on what basis. And then if you look at that in conjunction with, it kind of is just unsaid that the amount of the grant in C is capped, but it doesn't say, whether there is a formula for determining it or whether they could do, a $5,000 grant across the board. I mean, I think the way that this is written, they have the flexibility to ignore D2B, the subsequent priority stuff, because it says may exercise its discretion. They could just ignore this and say $5,000 across the board.
Yep, I hear you. I mean, that's part of my problem. Does the second group, to get into the second group, you don't have to show that you didn't receive any money elsewhere. Do you have to show an economic loss on your 2020 tax return?
Yes. Everybody to qualify for this money has to check that box. Tax loss for 2020.
Okay. And it doesn't have anything to do for this other group. It doesn't have anything to do. Let's assume they're long-standing businesses. There's no relationship to the tax loss from 2019, 2020. It's just to show you declaring a loss in 2020.
That's correct.
Yeah. Okay.
I think the other way to think about this is like this. This is all here because the underlying premise is this isn't enough money to help everybody. So we have to figure out a way to give priority to businesses to split up a pie that isn't big enough. If there were enough money, we wouldn't even need any of this stuff. And that's sort of why the priority for first, you help the people who have received nothing else.
Right.
If there's anything left over, figure out a way to help whoever's left in whatever way you can.
This reminds me of, let's assume that the first 5 million goes out of the door onto our priority people, which was always the initial group that was heralded as why we wanted to do this. And there's $5 million less. It strikes me very similar to, I can't remember the name of the governor's fund when Shumlin was governor. We said, let me have $5 million and I'll give it out to businesses however I see fit. There was a name for that. And I don't see this as much different at this point. And on the flip side, one of the things I think is important is we're reserving, if there is extra money, we're reserving it for businesses. But the whole concern that the Senate has was to target this money to those businesses that were most in need. Anyhow, that's very helpful. Let's see what time it is. Joan, I'm certainly going to give you an opportunity to comment on all of this, and I will be working with the House. I know that the House and we want to get this done very quickly, and I'm sure there's a solution to it. But I'd like to hear your thoughts in the next 10 minutes, if you can. We have to get back to UI fraud, but
sure. Thanks. Joan Goldstein, Commissioner of Economic Development. We agree very much with what House has proposed. As David succinctly described, this was designed as a gap recovery in between federal assistance. Now that we know that there is federal assistance, we did not go in and design this to be funded through ARPA. That was something through Senate Appropriations. So I think what they've laid out here is a very sound approach, very prudent. I don't think it's anything like enterprise fund, what you're referring to. This has to have a nexus to COVID And that's why House put in all those different considerations within the secondary priority. If we don't do this with a secondary priority, it means that all those people who are still hurting are going to have to wait for us to agree on another program, which might take another 4 months. So I'm not sure we have that luxury of time. I do not view this as a total discretionary pot of money. This will be one program that we would design, and we would look, like if you're a new business, you only have 2020. That's what we look at. If you're a business that's been in existence and you received PPP before, we would add that back into your 2020 loss. We need that flexibility so that we're not closing the door on all these people and waiting for us to come back to the drawing board. It's also very difficult to create another program while we're executing on the one that will hopefully eventually get passed in this fast track. So I would sort of plea or urge the committee to consider this secondary priority. It's not, there are plenty of lodging properties that got help, but are still not operating at full capacity. And I think if we're looking at net loss on the tax return, I think that's a real good indication. The reason why we don't want the award pegged to only that loss is, as we all know, there may be other expenses in there like depreciation that, why would that limit their award? It doesn't really make much sense. So I do hope that you could reach agreement with House. I do think it's a sound approach.
Can I ask you, thank you for that, Joan. I appreciate the clarification on the enterprise zone. You're right, it does have to be related to COVID for sure. But once it is, I think there's wide discretion. Do you, what was I going to ask? I'm drawing a blank here. Does anybody else have any questions while I think about my question for Joan at this point? Okay. Have you been given some, this has been around for a while, certainly the variables on the second tier. Have you thought about what those guidelines, I mean, I might have more comfort if I saw those guidelines and they were followed. Have you given any thought to writing the guidelines on all of those criteria?
We interpret it the way David explained it. We don't interpret it that it has to meet all of those criteria. It was a way of giving us examples of, so for example, let's say we take care of the first priority, second priority comes in, you have a lodging property that's been pretty much closed versus another company that may have suffered a loss but was not limited by the executive order, as an example. I do think we need that judgment. If you want to make it so stringent, again, we'll get back into a situation where the statute has to be changed in order to accommodate somebody who's clearly been adversely impacted by COVID. I don't have the guidelines yet. No, we've been.
How do you envision dealing with first comes, first served? Let's say after the 30 days or even within within the 30 days, you get a business that's, has need, but doesn't qualify for the priority. And you're ready to give them a grant. And then another business comes in and it's clearly a much more needy proposition. How are you going to stagger that? I mean, people are going to be filing these things as we go. Are you going to do it on a first come, first serve basis? So someone comes in on 31st day, they have a $10,000 need, you give them $10,000, and then the next person comes in and has a $100,000 need, but you don't have any money left, they're out of luck?
The prioritization will be that those who received no help before would be given first priority for payment. So that means that in actuality, what will happen is we will have a queue. We will probably design the application so that they have to answer that question and they have to answer questions about previous help. And those who didn't get previous help will be able to sort by that, both in terms of review and particularly in terms of payment. So each and every week as we come up with payment files, we'll ensure that it's only those who didn't get any help before. as for after the 30 days, we will still do the sort that those who did not receive help before get first priority. For all the rest, I don't know how we could possibly do that. Again, loss is a very relative term. $100,000 loss and a $10,000 loss to a very small company could be, an existential threat, whereas a $10,000 loss to a larger company, not so much. So if we don't do first come, first serve, you're talking about a deadline, and the deadline means then we have to sort through everything and rank it accordingly. I don't think that saves any time or gets anything out to people.
I'm not suggesting a right way. I'm just trying to understand it. So basically,
we could sort.
In the second tier, you're saying it will be first come, first serve unless you've received no funds. And then you jump to the head of the line of people who are being processed. Okay.
Yeah.
Any other questions for Joan? I hope committee members, well, we can talk a little bit about this. I want to move back to, if Damien is with us, he is, back to the fraud amendment. Joan, thank you very much.
Can I just ask a question? Where is this going after this? Like what is the plan?
That may be a bigger question than I answer. I think what the appropriations committees want Representative Marcotte and myself to reach agreement, and then they will put that into H315 and avoid a conference committee on that. There are three issues apparently that are holding up concurrence. Sides.
May I just ask Joan, as people tend to want to include ARPA money in before we understand the guidance and who's affected how, are you clearer on ARPA? I mean, are you clearer on the money coming through ARPA to businesses? Are you much clearer on that than all of us are?
No, not so much. I mean, we have a broad understanding that there's a restaurant stabilization fund and more money for shuttered venues and
right.
And the state, we don't have the money yet for the state discretionary. So no, and that's why we were taken aback that this was the funding source. Again, we wanted this to be the stopgap, either general fund or CRF. So yeah, we know that there's some money out. There'll be money out there for restaurants from the SBA program, but it's a national program. So we do want to make use, possible use of funds for businesses.
Will that be administered through ACCD or through the Restaurant Association? That's the questions like that. That does not come to ACCD. That is an SBA originated program that applicants would directly apply to SBA. Right. Okay.
Like shuttered venues and others and idle. And so I don't know. I mean, we've got so this, I guess this is anticipating that we'll be able to do this with the discretionary pot from the state that goes to the state,
which is a bit of a leap at this point.
Yeah, and that's not the administration's proposal, just to be clear.
Oh, yeah.
And just one final thing, Joan, I think you answered this already, that the way the House language exists on the amount of the grant being not to exceed the lesser of 3 months fixed cost or $150,000, your intent at this point is to interpret that as those are the two choices, as opposed to getting into massaging the numbers and giving a lesser amount if there's not as much loss. So let's assume there was a loss of 1 month fixed costs, you would still give out 3 months of fixed costs.
Yeah, I guess we have to be careful of defining loss. Again, if we are defining it as net profit or net income from a tax return, we have to remember there's a lot of other expenses in there. And so I don't know, I'm not sure I know what you mean when you say if they only had 1 month of fixed loss.
No, let me say it.
Okay.
You determine that the amount of the net operating loss is $10,000. And when you look at the business, their fixed costs are $15,000. The way the language is written from the House, you could theoretically give 10,000, but I thought I heard you say that that's too complicated and you would give out the $15,000.
Yeah, so again, it's going to be situation specific. So what I mean by that is in the new business scenario, we thought 3 months of fixed expenses. Why? Because they're new and they probably had a very large loss. But this is where we have to look at the financials. We have to look at it to say that, but to just say that it's only based on the net loss and it can't be anything more could conceivably miss the point of giving them funds to help them survive. If it's a business that was in existence before, then you would probably look at what that delta was, right? To really determine what their unmet need is. So we have that kind of mindset anyway from the prior rounds. I don't think we're going to ignore that entirely. We do need to see. I mean, we don't want to pay people more than what they've lost. We just don't want it to say the amount on their tax return, just because there's so much variability in that. And I think tax loss is probably a better way to call it than operating loss, only because operating loss connotates that it's all, you would add back in depreciation and stuff. And we don't want to get into a whole financial analysis as we are trying to administer recovery grants, not to that level where you're starting to go deep into their.
Okay. Thank you. I really,
Thanks.
I appreciate it. Thank you. Okay, so Damien, you're on. You want to pull up on your screen the amendment and just focus on the two changes or whatever changes you've made.
Sure. So I've pulled it up right to the first change, which is on page 2, line 14, and we've added in the words "to the extent practicable." And then that's relating to identifying the number of fraud determinations that are appealed and the percentage of those appeals that are reversed, or those determinations that are reversed on appeal. The second change here is in subdivision C2, or we added subdivision C2 on page 4, lines 11 to 14. This provides that the department may omit from the report information regarding techniques, procedures, and guidelines for unemployment insurance fraud investigations or prosecution if the disclosure of that information could reasonably be expected to risk circumvention of the law. And this is not verbatim, but it matches up to our standard for the Public Records Act, which provides an exemption for the disclosure of techniques and procedures for law enforcement investigations or prosecutions, or the disclosure of guidelines for law enforcement investigations or prosecutions if such disclosure could reasonably be expected to risk circumvention of the law. So it's essentially the same language, just slightly condensed. And then the last change here is on page 5, lines 1 through 3. We've amended the definition of an unemployment insurance fraud to mean the intentional misrepresentation or knowing non-disclosure of a material fact by a claimant or any other entity for the purposes of obtaining unemployment insurance benefits. And that's to cover the issue when you have, for example, a criminal entity or organization attempting to carry out a widespread identity theft scheme or something like that to defraud the system.
Okay, does anybody have any questions on the amendment before us? Okay, Senator Brock, would you like to move the amendment?
I would like to move the amendment.
Okay, any further discussion? Senator Rahm.
So I apologize for missing some of the back and forth. I had another obligation. But I appreciate Senator Brock, this has been a concern of yours throughout the bill. And you've worked with Senator Sorokin on something that kind of aligns with efforts in motion and is, not capturing people who I think are making honest mistakes or, kind of small de minimis fraud that might really be a mistake. I have concerns about furthering narrative around fraud right now. I think as the chair has brought up, I would be willing to vote yes in the spirit of bipartisanship, but I just am wondering if this also secures your vote for the overall bill, which I think has moved really far toward that same spirit of bipartisanship.
Unfortunately, it does not. I still have the concerns that I have expressed previously regarding the overall bill, and I'm happy that the negotiations that Senator Sorokin and I engaged in for a considerable period of time certainly did move us closer and added some very positive things to the bill. But overall, I still have concerns about the overall bill, and unfortunately, I cannot support it.
What are those overall concerns that are
the overall concerns are and I've expressed these previously. They're the same comments that I've expressed. There's nothing new. The same issues that such an overwhelming number of business interests in the state have expressed regarding is that although the bill ostensibly provides some short-term deferred relief, the long-term trajectory, and particularly regarding the size of the projected trust fund balance is much too high relative to the risk and where it ought to be, in my opinion. And secondly, the addition of a permanent benefit. I indicated that I would be supportive, for example, of the dependent benefit if it were limited to a shorter term during, to deal with the effects of the COVID crisis. I don't believe that it's wise for us to adopt a long-term permanent benefit, particularly with relatively limited review at this point of the effects of that. And I'm particularly concerned about adding additional continuing long-term benefits in the midst of a pandemic when the ability or the state's ability to collect that long-term is something I think that needs further scrutiny. Those are my principal concerns.
So I just want to say that I'm going to sign on to this. People can vote however they want. I'm going to, and I didn't expect Senator Brock to change his vote for this. I didn't ask him to do that at all. I hope he won't continue the debate on the floor on this, and we'll focus.
I do not intend to. I think we've debated enough.
Mostly on the fraud amendment. And I do think, in fairness to Senator Brock, I'll admit I'm not a big fan of highlighting fraud at this time, but he did agree to do it on third reading. He did agree to change the title. He did agree to add misclassification, and he did agree to get rid of some of the findings, which I think can be read by somebody just as a layperson, not understanding what we're trying to do, as potentially having a bad optics. So I've told him that I will sign on with him. But we have not talked about this as a committee offline. So if you want to vote no, you can vote no. I do hope this will pass out of the committee. So any further discussion?
Yeah, no, I mentioned, on the floor, there may be pieces of the findings I discussed by way of background as to why the bill is being introduced. But as Senator Sorokin and I discussed, I removed it from the bill so that it doesn't go along with the language going along with it.
Okay. We can do this by a show of hands initially, see if we're okay with it.
I have texted Becca to tell her that we're about to vote on this. So anyway, I hope she'll join us.
We could hold it open for her as well. Though I'm not sure I want to do anything but adjourn after this. I don't know how we could hold it open for her.
Right.
So is she going to, I want to, after we do this, I want to just get your feedback of where you want me to go on this negotiation. It does feel a little bit like the enterprise fund to me, I have to say.
Nathan, is Becca coming in by any chance? He's here.
I haven't received anything.
Let's take a show of hands. Maybe we don't necessarily need her vote. All those in favor of Senator Brock and my amendment, raise your hand. All those opposed? Okay, we'll leave it at that, 3-1. Senator Brock, you should probably get it up to the secretary's
Get it up
office.
to Boomer.
Okay.
311 is
311. Okay, so let's go back to, anybody have any thoughts, direction for me on this? It's not easy. What I propose back to them is say, I think it would be very simple. They did say yesterday, would you go along with a de minimis amount? So I don't know whether it's you've received $10,000 or $50,000 or I think when I wrote them, how about 10% of your change in income from 2019 to 2020? And if you've received grants for 10% of that amount or less than 10% of the amount, then you're in the door for the second tier group. I'm open to any kind of ideas, but so they said de minimis. So that'll make it simple,
De minimis to what? It has to be in relation to something.
De minimis, well, you start out with de minimis, how much the first group has gotten no help.
Right.
The second group would have received a de minimis amount of help. How do you define de minimis? I always think of de minimis as being very small, where you're getting screwed by being right on the cusp.
Right.
So it would be for businesses that have received very little, but a business that receives $5,000 that needs 10, de minimis works very well. If they receive $5,000 and they need 5 million, de minimis doesn't work very well. So I don't know.
Nor will it keep it open after COVID. I mean, so part of the discussion here is your expectation is that you're going to continue to be open and that you're going to continue in business. So that
there is a I can't remember the exact word. There is something, I don't know if they took it out or not, to say they have to present a good faith attestation that they will reopen if they're still closed right now.
Right.
This is a self-certifying honor system here, certainly for sure. I think that the problem that has always given me discomfort here is, as a legislature, we would spend a lot of time designing this program, and because we have to get money out the door quickly, and I don't think it's the kind of pressure we had before, because they've already been waiting 6 months, and as this thing has hobbled along, and the big pot of money is probably going to come within a couple of months afterwards. So, and I know Joint Fiscal had a lot of problems that expressed similar to ours about certain businesses, because the way it was structured, were in industries that people were scratching their heads as to why they were qualifying for $50,000 or whatever. So that's all. I think the difference is we're dealing with the second tier, and how do we handle that second tier? I think what the House is proposing is it's pretty wide open in the discretion.
I would stick to your de minimis, a definition of de minimis that can be consistently applied.
Yep.
And other than that, I think it needs to go. This was originally.
It's going to go. It will go. It will go.
And have we resolved the syncing up? I mean, you know more than we do at this point. Have we resolved the syncing up of the feds and the state?
Do you guys feel that this conversation should be on YouTube or not, I don't know the protocols really. We're talking about a strategy and a negotiation with the House. I'm not sure that's
I think
the kind of thing we usually publicly talk about
Right.
in committee. So I see Randy nodding his head. So why don't we just go